Okay, now the last section of this lecture is that we're looking at the ratification of human rights treaties, how human rights treaties become treaties. So at the end of the last section, we talked about this adoption by the General Assembly as that final stage in terms of where a treaty is at. Now, once a treaty has been adopted by the General Assembly, it's then open for signature and ratification. And so this starts the process. But what happens is that states can volunteer to make that treaty law in the country. So that starts when they put their signature on the treaty. And what that means, when they sign that treaty, is they're going to take it back to their country to explore it becoming part of their legal system. So the state expresses their interest to ratify it, they take it back to their country from the United Nations, and they start looking at adapting that as law. And that can mean that they kind of look at how it fits with their existing law, what changes need to be made. So the first stage is signature. Signature doesn't create legal obligations, but it kind of creates a soft law obligations that you don't go against the object and the purpose of the treaty. The next process is ratification, and that means that that country then passes that treaty as law in the country. Now that doesn't mean it actually is law, because that's more the process of that law being put into place in the country. Ratification just means that they agree to be legally bound by that treaty. What the legally binding obligations is and how it's reflected in the national system is going to vary country to country. Now, ratification is important because for a treaty to become enforced, for a treaty to become an international treaty, you need to have a certain number of ratifications, as was mentioned before. So like CRC needed 20 ratifications, ICCPR needed 35 ratifications. Now, just in terms of names, you also sometimes see that states will be what's called like they accede, or there's an accession to the treaty. What that basically means is if that treaty is already in force, if it's already got the 35 or however many countries that have ratified it, when a state then agrees to it, they accede to it. But basically, whether it's ratification or accession, that makes no difference. It's just a different name. Now, similarly, there's also the term of succeeding to a treaty. Now, what that means is that if a country kind of changes its status, but that treaty was existing in a country, that treaty continues on being in that country. So, for example, when Timor-Leste became independent from Indonesia, now when Timor-Leste was part of Indonesia, it meant it was part of a number of human rights treaties which Indonesia had agreed to, which I think was CRC and CEDAW. So that means that even when Timor-Leste became independent, they didn't start with a clean slate, because in their jurisdiction, CRC and CEDAW was already acting. They already had those laws there, so they can't take it away. So in a sense, Timor-Leste then seceded to those treaties. Through its transformation, those treaties were already there. Now, what happened in reality is that then the new independent Timorese government ratified those treaties itself, and so it became law in that country. But even if they didn't ratify it, it would still be law in that country. And that's what we see, for example, in Hong Kong. When Hong Kong was a colony of England, it was part of the treaties which the UK had ratified, including ICCPR. When it became part of China in 1977, it still had ICCPR, even though it wasn't a colony of England, even though it was a part of China, because ICCPR was in that country, you can't take it away. Human rights are inalienable, you can't take those rights away. So it meant that Hong Kong still has those laws like ICCPR, even though it's not part of England anymore. Okay, now the last concept here is interforce. Interforce means that it's recognised as an international treaty. That is the necessary number of states have ratified that treaty, and that it's now has legally binding obligations. Now, what that means in reality is that, say, for a human rights treaty, is that a treaty body is set up that states can then pressure other states to kind of implement those laws. Not that it happens that much, but it means that states then have legally binding obligations to that treaty because it now is into force. Okay. So this is just some examples here of this process. And so if you go to the UN webpage, you'll see it's got a list of every time you see a treaty that is signed. So here we have the signature, which was done in 2006. We have the Secretary of the Foreign Affairs of the Philippines giving a signature to the optional protocol of ICCPR on abolishing the death penalty. So it means that he's the Filipino UN diplomat. He would have gone there and said, our country is interested in ratifying this treaty. And here we are going to sign the treaty. So he's there pictured signing whatever it is, a book on that records the signatures, the optional protocol. So every time a signature occurs, there's a picture is taken and it's documented on the UN webpage. Now, what happens is once it's ratified, for example, and this is a different ratification, is that that state then it comes back to the United Nations with what is known as the instruments of ratification, which basically is the document which confirms that this country has ratified that treaty. So here we have a Myanmar diplomat, His Excellency Mr. U Chor-tin, Union Minister for International Cooperation of the Republic of the Union of Myanmar. He deposits the instruments of ratification for optional protocol on CRC, children in armed conflict. And that was just about a year ago. So I mean that Myanmar is now legally bound by that treaty. They've ratified it, and they then deposit the instrument of ratification at the United Nations and have their photo taken. Okay, now a couple of other things we need to understand about this process of ratification is that during this process of ratification, states often look at how that treaty compares with their national laws, but also they can make what's called reservations and understandings. The reservations is where they can take out a right. They can say, we agree to this whole treaty, but we're going to reserve, or we're going to put this right to one side. For example, here we have the reservation made by the Republic of Korea that it does not consider itself bound by Article 9 of CEDAW. So when it ratified CEDAW, it says we agree to all the articles, but Article 9, which is on equal nationality, they don't agree to. So in this case, they said that men can pass on their nationality, but women can't. And they're not going to be bound by that part of the CEDAW Convention. Now, what should happen with reservations is eventually countries should then withdraw those reservations. That's the process. So early on, it may be too difficult to make these changes because you've got to have constitutional changes, for example. But then over the following years, those reservations are gradually withdrawn. We've seen that for Thailand, for example, because Thailand had exactly the same reservation about women not having equal laws or equal powers to give citizenship to their children. But that was a reservation, and now I'm pretty sure Thailand has withdrawn that. I'm not quite sure if Korea has withdrawn this reservation, but there would be pressure from the United Nations that eventually would have to withdraw this reservation. Now, another one is understanding. Understandings of just clarifying how you interpret that treaty or how you interpret that right. So a very common understanding is about the right of self-determination, which we may come back to when we look at ICCPR and ICCR. But various nations say, we understand that self-determination does not allow ethnic secession. It only allows states to decolonize. But here we have an understanding that Malaysia gave about rights in CEDAW. It said that the government of Malaysia declares that Malaysia's accession to CEDAW is subject to the understanding of the provisions of the Convention do not conflict with the provisions of Islamic Sharia law and the Federal Constitution of Malaysia. So what they're basically saying here, and this can undercut a lot of the authority of CEDAW, is saying that if there's a conflict between Sharia law and the Constitution in terms of women's rights, that Sharia law and the Constitution will prevail. That will give their interpretation. So CEDAW cannot overrule the Constitution and Sharia law. Now that may limit women's rights in, say, family law in Malaysia. Okay, there's just a couple more things to cover. Now, firstly, in terms of ratifying treaties, this is the 9 treaties and how many countries have ratified. It's important to understand that human rights are not fringe public international law. Human rights are very widely accepted. There's 193 countries in the world. When you look at this, for most of the treaties, most countries have ratified. So all but 2 have over 170 ratifications, which means that all but 2 are ratified. There's only like a small number of countries which have not ratified. Now, unfortunately, some Southeast Asian countries are some with a poor record. That's Myanmar, Singapore, Malaysia, and Brunei have only ratified 2 or 3 treaties. If you look at Latin America and Africa and Europe, most countries that have ratified almost all the treaties. Now, there are 2 exceptions, of course. The Migrant Workers Convention, with only 55 ratifications, and also enforced disappearances. Now, there's different reasons. Enforced disappearances is because it's a fairly young and new treaty and it takes time, so there's not that many ratifications. And also it is a treaty which some countries may find threatened to their authority. But also migrant workers. The challenge here, as we'll cover later in the semester, most countries that accept migrant workers don't want to ratify the treaty because they fear it may give too many rights and protections to migrant workers. So that's why those two have very low ratifications. But the key point here is that you look at all those treaties have 170 plus, which means there's just basically 15 to 20 countries which have not ratified those main treaties. And so they're very small in number. Okay. Now the last point here is looking at why states ratify treaties. We're just going to look at this very quickly because it will be covered later. But the question is, why would states volunteer to limit their power? Why would they decide to be part of these treaties if they don't have to? If they could just ignore that. There's a whole number of reasons why they ratify. An important one is it's good for their self-image. They appear like a human rights supporting country. So even if you've got a bad human rights record like Cambodia, you can still ratify a lot of human rights treaties and pretend that means you're respecting human rights. There's also a bit of kind of what you may call herd mentality, that every country ratifies these treaties and other countries don't want to be left behind, because it can be embarrassing. Like as we'll come back, we see that the United States has not ratified children's rights or women's rights, which is embarrassing to many Americans. They haven't ratified these key treaties. So there is a kind of a herd mentality that countries tend to ratify together. Also, there's strong advocacy to ratify treaties, and so when there's strong civil rights, that kind of supports the ratification of treaties. Another important one, particularly in Southeast Asia, is that in periods of transitional justice, in periods when, for example, you come out of a dictatorship, as what happened under Suharto in Indonesia, Marcos in the Philippines, even the end of military rule in Thailand, and even to a certain extent in Myanmar. In those periods when there's kind of growing democracy, the countries tend to ratify human rights. So Philippines ratified most of its human rights in the late 80s, early 90s, at the end of the Marcos period. Indonesia in the early 2000s, at the end of the Suharto period. Thailand in the 1990s, the end of military rule there. So transitional periods lead to more ratification. Now, there are other forces that occur at the international level, say advocacy from the United Nations and INGOs. And as you'll find, so the UPR process puts a lot of pressure on states to ratify. It can also be that if you want to be part of an international organization, whether it's the WTO or the OECD, those organizations, there's kind of pressure to ratify treaties as well. Okay. Sometimes they ratify these treaties to try and avoid sanctions and penalties. And this may be the case in Cambodia, that they often kind of fly very close or get a lot of international criticism. They can avoid those sanctions and penalties by ratifying those treaties. Now, a final one is that sometimes states ratify quite cynically, thinking, well, if you ratify, it's not going to make any difference. So, like, for example, North Korea ratifying treaties, saying they're not going to implement at the domestic level. But you see, there's a whole variety of reasons why states ratify, some good and some not so good. But we'll kind of develop these ideas and also look at possibly a bit around the advocacy of getting states to ratify treaties. Okay, so that ends this lecture and this section here. So we're going to stop recording.